Just before last call in a beachfront party area, two sets of men observed a woman that was a little too drunk, a little too out of it. It's what they chose to do, having realized she was so vulnerable, that proved the litmus test for them. The events of December 1st, 2019 stand to show that it is perhaps not all men that would assault women when given the opportunity, but certainly Lance Corporal Swisher. This is Conduct and Becoming. I'm Erin, and I'm your host. A heads up, I will be describing details of sexual assault in this episode. I'm specifically choosing to provide these details because the men involved in this case were so brazen in their actions, and because the deeply discomforting details are significant to the appellate issues. Further, I believe there's a risk in overly sanitizing the details of this particular assault. As always, I give this heads up so you can make the decisions that are right for you, with respect to what you choose to listen to. In the early morning hours of Sunday, December 1st, 2019, a group of women who had been drinking and enjoying their time together at Senor Frog's at Broadway at the Beach in Myrtle Beach, South Carolina, got a little too rambunctious. They'd been overserved, were too intoxicated, and they were asked to leave. When the group left, two security guards helping the women end their night noticed a pair of men sort of hovering around one of the women, who we'll refer to as Jane. Jane's friends made a quick detour to the bathroom before security assisted them in locating the taxi stand. But those security guards realized someone was missing. Jane. So they turned their focus away from helping the women into cabs and toward searching the area, toward finding Jane. They discovered her behind a coffee kiosk, covered in her own vomit, being sexually assaulted by Lance Corporal Swisher and his friend Kenneth Simmons. It's all very Brock Turner of them. When those security guards first came upon the scene, they saw two sets of shoes lying down, then discovered Jane lying on the ground. She was on her back, and her pants were pulled down. Swisher was lying on top of her, with his penis exposed. They saw Simmons near Jane's head, while he was similarly exposed. They saw Jane react to the bright light of the flashlight, and demanded that Swisher get off Jane. Swisher hurried to claim he was trying to help her, and began to try to cover her up. One of the guards inquired how Swisher could possibly be trying to help her with his penis in his hand and while she was so clearly intoxicated. They observed Jane to be very out of it. When they asked her if she needed help getting up, she was unresponsive. But they helped her up anyway, pulled her pants back up, and buttoned them for her. One of the guards lifted her and carried her to a planter ledge so she could sit down. He described the smell of alcohol on her and confirmed that she was drunk, out of it, and scared. She didn't know what was going on, and she was confused. Her vomit streaked her clothes, the ground, and her hair. She was unaware of it, but she was missing a shoe. If I had to guess, based solely on the mugshots I encountered while researching this case, I suspect there was a scuffle while security pulled these men off an unconscious woman and detained them. Jane had consumed enough alcohol to black out. Hours after the assault, her blood alcohol content was still twice the legal limit. The last thing she had remembered was drinking at the bar with her friends. When they were interviewed by law enforcement, Swisher and Simmons admitted they knew she was highly intoxicated, and admitted to providing her with cocaine. Simmons had purchased the cocaine earlier in the night with Swisher's money, and both Simmons and Swisher consumed several bumps of cocaine before offering some to Jane. It's reported that Simmons offered the cocaine in exchange for oral sex, and that Jane accepted his offer. But I think it's important to highlight just how unclear it is who advanced that claim or what sort of merit it has. The men made all those admissions during their investigation. During the investigation, it also came out that Swisher forced the largely unconscious Jane into orally copulating him, as well as performing digital penetration and attempting penetrative sex without her permission. Both Swisher and Simmons were held on $50,153 bail amounts. Simmons, a 35-year-old, was a civilian. He wasn't subject to the UCMJ. But 23-year-old Swisher, on the other hand, was an active-duty Marine. That meant that Marine Corps prosecutors could not take jurisdiction over Simmons, and he was subject to civilian prosecution by the state of South Carolina. While it is certainly true that South Carolina could have prosecuted both of them, and that both were originally charged by the state with third-degree criminal sexual assault and public intoxication, there are a variety of reasons that it makes sense to allow the Marine Corps to prosecute Swisher, including conserving state resources. For his role in the night's events, South Carolina prosecutors struck a plea agreement with Simmons. In exchange for his plea that he was guilty of criminal sexual conduct in the third degree, he received a 5-year suspended prison sentence, sex offender registration, and 3 years of probation. Unlike Simmons, Swisher elected to take his matter to court-martial. He contested one specification of attempted sexual assault, one specification of wrongful use of cocaine, 2 specifications of sexual assault, and 2 specifications of aiding and abetting sexual assault. During his panel selection, Swisher challenged 16 of the 18 panel members, resulting in dismissal of 8 of them. Swisher later claimed that 5 of those 8 that remained on his panel should have been excused. If you've been following the Diddy trial, you may have read about the difficulties of jury selection, especially in cases where attorneys might inquire whether you or anyone you know has been a victim of sexual assault. I confess I don't know many women who can answer that question with no. No, they don't know anyone who has been a victim of sexual assault. One of the 5 challenged panelists shared that his stepsister was the victim of rape. After a thorough voir dire, he was permitted to sit. He was challenged again during the trial after he asked follow-up questions of an expert witness. I spoke sort of tangentially about the challenges of finding enough impartial people to field a court-martial in episode 21, The Sullivan Case. The discussion at that time was sort of limited to the legal team because of the size of the Coast Guard and, more specifically, the size of the Coast Guard legal teams. But those challenges are relevant to the various services more generally. Trying to find a panel that doesn't know the parties and hasn't been exposed to media coverage can be an issue. The question of prior knowledge was the basis for Swisher challenging another panelist. Going into panel selection, that panelist confessed he knew Swisher was accused of sexual assault. But by the end of panel selection, if not, frankly, at the beginning, that's information every panelist would have. For a couple of the other challenged panelists, Swisher focused on their lack of understanding of legal nuance around consent. But because that argument essentially boils down to this panelist doesn't have a thorough understanding of military criminal justice case law, it doesn't really amount to much. Swisher and his defense team chose an interesting strategy. In spite of his confessions to forced oral copulation and penetrative acts and multiple eyewitness reports, Swisher seems to have argued that because his DNA was not found in Jane's mouth or vulva, the sexual assault did not occur. When Jane's friends took the stand, they testified to the volume of alcohol she'd consumed that night and disclosed that they'd consumed marijuana before heading out. They reported that she vomited at least once before they got separated after the bar, and surveillance footage from that night showed that Jane was clearly intoxicated. Whether Jane was too intoxicated to consent revolved around whether she was capable of understanding the nature of the conduct at issue, or whether she was physically incapable of declining participation or communicating her unwillingness to engage in the sexual acts. I touched briefly on this issue in episode 23, the Ellerbrock case. But a review of my script notes seems to indicate that I toned down my comments on the evolution of this particular area of military justice. I understand that some people will hear this fact pattern or will read the fact pattern in the various opinions and conclude that this sexual assault was Jane's fault. They will hear that she consumed drugs and alcohol and wonder what she expected to happen. And to those people I offer this: she expected to be safe with her friends. She didn't expect to be separated from them, secreted off to the floor behind a coffee kiosk, and assaulted. As in episode 23, I'll remind everyone that victims of assault are imperfect, but that doesn't mean they deserved what happened or don't deserve justice. In addition to Jane's friends, Simmons testified that he and Swisher traded off assaulting Jane. He described the specific actions that he witnessed Swisher performing. He added that during the assault, Jane did not participate or verbalize anything, let alone consent. Simmons attested that he was the one that pulled Jane's pants down because he was the one with cocaine. I'm not sure how those two are necessarily logically connected. In what I believe is the most horrifying detail, Simmons described wiping vomit from Jane's mouth before he and Swisher continued their assault. After hearing from all the witnesses and watching the security camera video footage of Jane's clearly intoxicated state, the Marine Corps Recruit Depot Paris Island panel convicted Swisher of 1 specification of attempted sexual assault, 1 specification of wrongful use of cocaine, and 2 specifications of sexual assault. They acquitted him of those 2 specifications of aiding and abetting sexual assault. Pursuant to those convictions, the military judge sentenced Swisher to confinement for 54 months, a reduction from E3 to E1, and a dishonorable discharge. In my teaser for this episode, I think I described this as a case so not nice the NMCCA covered it twice. But I actually think that's inaccurate, because I believe the NMCCA has touched this case not twice but 3 times. You see, originally the NMCCA affirmed the findings and sentence. Then the court granted Swisher's motion for en banc reconsideration and withdrew their prior decision. That's rare in the appellate courts that I'm familiar with, but I'm uncertain of the numbers for the various CCAs. Pursuant to that reconsideration, the NMCCA set aside the conviction for attempted sexual assault, concluding the charge for attempted sexual assault did not state the proper mens rea. The court dismissed that charge with prejudice on the grounds that the specification failed to state an offense. They reassessed the sentence and affirmed it, determining that the military judge's decision to merge the attempted sexual assault with the completed sexual assaults did not change Swisher's punitive exposure. And I know that's sort of a weird spot for me to begin the legal beagle section, because we're sort of yada-yadaing some of the appellate review. But fear not, legal beagle, because we still have two opinions to talk about. After the NMCCA kicked that attempted sexual assault conviction, Swisher turned to the Court of Appeal for the Armed Forces, arguing his sentence was inappropriately severe, specifically alleging that the NMCCA should have considered Simmons's sentence in determining sentence appropriateness for Swisher. The NMCCA declined to compare Simmons's sentence with Swisher's because the sentence was imposed by South Carolina, which is notably not a federal armed service, and Simmons was convicted of different crimes. They highlighted that they observed there was no precedent that required them to compare the two sentences, to compare apples to oranges. And they do seem quite different. Simmons was not subject to the UCMJ and would never have been convicted by a Marine Corps panel or sentenced by a military judge. Simmons hadn't signed on to be one of the few, the proud, the Marines. He didn't sign up to protect and defend the Constitution. He didn't sign up to be restricted by the UCMJ. He hadn't signed up to be held to a higher standard, so he wasn't. And I do think it's worth mentioning here that Simmons negotiated his plea agreement, and in doing so, spared South Carolina prosecutors from having to take his case to trial. Further, in pleading guilty, Simmons ostensibly took accountability for his actions. In terms of the disparity in their confinement, Simmons spent approximately 230 days confined prior to his negotiated release. Conversely, Swisher spent, from what I can determine, just 8 days in confinement prior to his conviction. But CAF invited the NMCCA to hold their horses, concluding that it abused its discretion by sidestepping some analysis that applicable precedent required. That is, it may well be true that the sentences were apples and oranges, but the NMCCA had to show their work. So, CAF remanded the matter back to the NMCCA to make the appropriate determinations. The various CCAs have discretion to consider and compare other sentences when reviewing a matter for appropriateness. And there is no precedent that requires comparison between certain cases. But as CAF had previously laid out, an appellant bears the burden of showing that cited cases are closely related to his case, and showing that the sentences are highly disparate. When those two factors, those two showings have been made, the government must show a rational basis for the disparity. They have to point at the disparities and give some kind of explanation as to why they make sense. That precedent required the NMCCA to decide whether Swisher met that burden. They couldn't just wave their hands, blame the civilian jurisdiction, and skip that step. When the NMCCA took a third crack at this case, they again affirmed the sentence, but this time they explained their reasoning. First, the NMCCA concluded, yes, Swisher's case and Simmons's case were closely related because they were co-actors in a common crime. Second, they concluded that yes, the sentences were highly disparate. A suspended 5-year sentence is vastly different than approximately 4.5 years of confinement. Swisher's sentence also meant that he lost his job with his dishonorable discharge, whereas Simmons was required by the terms of his probation to stay employed and submit to random drug and alcohol testing. With those two prongs met, the court turned to the government's explanation for the disparity. They highlighted that Simmons negotiated that plea agreement and agreed to testify against Swisher. They returned to their previous observation that Swisher and Simmons were convicted of different crimes, and that those differences included Swisher's conviction for his wrongful use of cocaine. In sum, they applied the same logic they applied before, but did it in a more structured manner. They recounted the egregious sexual assault for a third time, this time omitting the multiple mentions of vomit, and nevertheless affirmed the judge's sentence of 54 months of confinement, reduction to E1, and a dishonorable discharge. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time when we turn to the question of just who qualifies as law enforcement. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense.